Good day to our lecturer, Madam Nadia and friends. We are from Group 6 and will be presenting on our Assignment 1 topic, Pre-Incorporation of Contracts and Incorporation of Companies. Our group consists of 4 members, Uma, Marilyn, Anusha and Nelly. The outline of the presentation will be on the concept of promoters, pre-incorporation contracts, incorporation of a company and lifting of the corporate veil. Firstly, we will be briefing you on the concept of promoters. Generally, promoters in company law is the person who applies for incorporation of a company. However, Cockburn CJ A TV Cross V Grant 1877 described it as the one who undertakes to form a company with reference to a project and to set it going, and also who takes the necessary step to accomplish that purpose. In this case, it is obvious that Candy and Caramel, who are the promoters, is by setting up the business and entering into a pre-incorporation contract. The duties of promoters includes fiduciary relationship, which is a relationship between the company and to those persons who him induce to become shareholders in it. Therefore, based on the case TV Cross V Grant 1877, the promoters have fiduciary duty towards the company to act in good faith and to ensure that there is no conflict of interest. The most important implication is that the promoter cannot make a good profit from establishing the company without full disclosure of the profit to either an independent board of directors, which can be seen under case of Gluckskin v. Barnes 1900, where Lord Hasbury stated that the promoter of the company was under a duty to make explicit declaration of the profit they make from a sale of the property. Apart from that, the case Habib Abdul Rahman v. Abdul Qadir 1808 till 1890 for key 193 straight settlement Supreme Court stated that the liability can be avoided and business transaction between promoter and his own company can be taken as place as long the promoter discloses the transaction in Memorandum of Association and Articles of Incorporation, and then the Board of Directors approve the transaction. With that, if Candy did not disclose, the company may resign the contract, or in certain circumstances, company may be able to claim the secret profit obtained from them.
Okay, for this part, I would like to describe about the principle of the incorporated contract. A pre-incorporation contract refers to contract where one party of the contract is a company that is yet to be incorporated. Therefore, pre-incorporated contract which are made before the company contract or agreement. The second one, ensure that you get rectified in order to get the company. The third one, promoter are responsible to act on behalf of the company. And the last one, if the pre-incorporated are not rectified, the promoter or on behalf to act on the company should be bound by the contract. Position in Malaysia, there is 2 sections, which is the first one is the section 35(1). Any contractor transaction purporting to enter the company prior its formation, or any of the person who act on behalf of the company prior to its formation may be rectified. Section 35(2). If the company failed to be rectified, the promoter will be personally bound by the contract. In these pages, I would like to talk about the effect of a Section 35. The first one is to enable the outsider to enforce the contract either company when it's rectified the contract. The second one is to against a person who purported to execute the contract on behalf of the non-existent company. And the last one, I would like to talk about the method for company to be rectified. The first one is the pre-incorporated is rectified, the company is bound by the contract. And the second one, there is a retrospectively process. And the third one, the person who purported to act in the name on behalf of the company should be bound by the contract if the company chooses to not be rectified.
Today I'm going to discuss about effect of incorporation. Section 16R5 tells about a body corporate exercising all the functions of an incorporated company of suing and being sued and having perpetual succession with power to hold a land. The first one is separate legal entity. The company is a legal person, artificial, having a distinct entity from its members. The cases that involve here is Salomon vs. Salomon, Lee vs. Lee's Air Farming, Hugh Suk Ying vs. Hugh Tin He or Hugh He, and People's Insurance Co. and Berhad. The second one is ability to own property. A company can own property in its own name. The cases that involved in here is Makara vs. Northern Assurance Co. Limited and Abdul Aziz bin Atan. The third one is ability to incur its own liability. Liability of a company is unlimited, liability of members is limited. Depends to the type of company, etc. Limited by shares or limited by guarantee. The cases that involve is rare application by Yi Yud Yi and Salomon vs. Salomon. The fourth one is ability to sue and being sued. A company can sue and be sued in its own name any wrong done to the company. Only the company can take action. The fifth one is perpetual succession. A company shall exist until properly worn out or struck off from the register. Its lifespan does not depend on the life of its members. The cases involved here is Real Neol Tedmon Abdul Aziz Akbar.
My name is Anusha. Today I'm going to explain about principle of lifting. The concept is a company is a legal person, is a separate entity from its members of shareholders. Then law will lift the corporate will, which is under statutory provision under judicial interpretation. Then first one is reduction of the number of members below minimum. For facilities, the task of an inspector to investigate the affair of the company. For investigation of the ownership for the company. Then the second one is under judicial interpretation.